Hello. So I am constantly reminded that people don't watch all of my videos and they haven't watched all of my videos. And I need to continually, since I don't index them, I need to continually address things. And that's fine. It gives me content to talk about. Every time the government restricts your freedom of speech, every time, for whatever reason, it doesn't really matter. For any reason, if the government restricts your freedom of speech, there is a test that can be used to see whether or not that restriction is constitutional. Every time, every time, every time. The trick is just figuring out the right test. If you are on government property that is not a traditional public forum, then it's a very easy test. It is the restriction reasonable, and is it viewpoint neutral? If it meets that, then the government can do it. If you're in a police department parking lot, if you're in the lobby of a building that is owned by the government, the test is the restriction reasonable, and is it viewpoint neutral? That's it. If you're on the street, a traditional public forum, and you're trying to film a traffic stop or an accident scene, and the police want you to move back, they're interfering with your First Amendment rights. They're interfering with your freedom of speech. In order to be able to do that, they have to be able to justify it in court if you ever challenge it. And that would be a time, place, or manner restriction. We saw that in Turner v. Driver. If you remember the holding of Turner v. Driver, it was that you have a right to film the police, subject to reasonable time, place, or manner restrictions. Reasonable time, place, and manner restrictions means that if the police need you to not be in a particular area at a particular time because that's their accident scene, then they can do that. Now, how far back can they make you go, etc.? That becomes a question of fact that I can't give you a bright line rule on. In order for the police to be able to justify their time, place, or manner restriction, it has to serve an important, significant, substantial government interest. They're all significant or important are the two you see most often. I've seen substantial, but significant or important. It's an intermediate test. It's an intermediate scrutiny test. And it has to be narrowly tailored to achieve that significant government interest. It has to be content neutral and viewpoint neutral. So the test the police have to satisfy is that. Is it an important or a significant government interest that they're trying to keep you out of this area? If yes, then proceed to the next step. Is their restriction viewpoint neutral and content neutral? If yes, proceed to the next step. Is their restriction narrowly tailored to achieve their significant or important government interest? If yes, then what they're doing is constitutional. It comports with the First Amendment restrictions. If the government was to make a law saying you can't film police, that's it. If they made a law that said you can't film police, that would be subject to strict scrutiny. Strict scrutiny, and these words are important. Instead of being a substantial or important or significant government interest, it has to be a compelling government interest, which is a more important government interest than an important government interest. And the second thing that it has to be in order for the government to be able to justify the restriction is that it has to be the least restrictive way that they can achieve that compelling government interest. If there's a less restrictive way on your speech that they can achieve that interest, then it doesn't comport with the First Amendment. So whatever their interest is in saying you can't film the police, period, would have to be compelling. If it is, then it'd have to be the least restrictive way possible of doing it. And who knows? I mean, we'd have to understand the compelling government interest at that point. Of course, if you're not on the street or if you're not on government property, then a non-government entity can control your actions much easier. They can just simply trespass you because they don't like you. And finally, there's two other forums that may play into it. Limited forums, which is where the government rents out like a hall for people to have a speech in or something like that. Essentially, if you're not one of the speakers, if you're not the person who rented the hall, then it is treated as a non-public forum for you, in which case any restrictions on your First Amendment right only have to be reasonable and viewpoint neutral. And the other one is the designated public forum. That's where you'll see these on military bases. They'll have a free speech zone. And inside that free speech zone, it's treated as a traditional public forum, in which case all the protections of a traditional public forum would apply for that particular patch of ground until the government decides to stop allowing that as a free speech zone. But every time the government interferes with your freedom of speech, every single time, they have to be able to justify it if you challenge it. So if the whole way this came about is somebody was interested in why the cops can tell you to get back on the sidewalk, assuming that we're not talking about jaywalking laws, assuming that it's not, there's no other conduct restriction that would apply, and it's a speech restriction that they're trying to enforce. They're just trying to enforce you viewing or filming, I should say, something. Then you'd have to run through that analysis. Does the officer have a significant or important or substantial government interest in controlling that scene? If yes, then you move on to the next step. Is his enforcement of it content neutral and viewpoint neutral? If he's allowing Channel 4 News, or if he's allowing a pro-police photographer to come up and film, let's just say that. Let's assume that neither photographer has a press pass, but let's say there's a pro-police photographer and an anti-police photographer. If he's allowing one to film and not the other to film, then that's not viewpoint neutral. If he's allowing neither to film, then it probably is viewpoint neutral. So if it is viewpoint neutral, then and you check that box, then you go on to the third step. Is it narrowly tailored to achieve that significant government interest? And if it is, then the cop was allowed to do it. If it's not, then the cop shouldn't be allowed to do it, and you should challenge it in court. And well, I guess the court determines all those things, not you. So anyway, I hope that helps. Thank you for watching. And I do like the questions. I love getting the questions and giving out the answers, and it might seem redundant. And if you're one of the people who already understand this stuff, then I'm sorry that I'm wasting your time. But if it seems like a lot of people don't, and so I'm going to keep doing it. Thanks for watching. Have a great day.